Hello, and welcome to the first in our two-part series on the EU Whistleblowing Directive 1 year on. My name is Nick Thorpe, and I'm an employment law partner, or labour lawyer, in Phil Fisher's London office. I'll be chairing today's panel discussion, and I'm joined today by colleagues and friends from Phil Fisher's European offices and wider network. During this two-part series, we'll be looking at developments in whistleblowing legislation across Europe, and in particular the transposition of the EU Whistleblowing Directive into national law. The title of the series is EU Whistleblowing Directive 1 year on. I say 1 year on as we take as our starting point for this series the dates 17 December 2021, when member states were required to transpose the directive into national law. However, as many of you will know, very few member states actually met this deadline. From memory, only 7 out of the total of 27 did. Even now, only around half the member states have fully transposed the directive. Today, we have the best in class here, with colleagues from countries that were some of the first to transpose the directive into national law. But we're now seeing a lot of activity in this area across Europe, with legislation very recently being approved and or adopted in Finland, Germany, Greece, Italy, Spain, Slovakia, and Romania. So this series is extremely timely for organisations with a European presence. Before I introduce today's panellists, some housekeeping. First, the slide you see on the screen below is a holding slide. There'll be no slide presentation today. This session is also being recorded, and we will share the recording with attendees after the event. We would also like the session to be as interactive as possible, and we would encourage you to ask questions during the session by typing them into the questions function. And I will put these to panelists either during or at the end of the session. If we do not get to your question, then don't worry, we will follow up with you afterwards. So if you have any burning questions at all on the new whistleblowing laws, please do include them in the questions function. Now, enough of me. Let me introduce today's panelists. First, it is with great pleasure to introduce Anneli Långberg. Anneli is an employment lawyer and partner in the Swedish law firm Filia. Filia is a partner firm in our eComlex network, and Anneli and I have worked closely together over a number of years. I'd then like to introduce my colleague and fellow partner, Laurence Dumas-Lambert, who heads up our team in Paris. Laurence assists French and international clients across a wide range of industries, and is particularly known and sought out for her expertise in the implementation of collective redundancies and the resolution of collective disputes. We then have Barry Walsh. Barry is the head of our employment team in Dublin. Barry is quoted in Chambers Europe as a fantastic solicitor and business partner who is a pleasure to work with even in difficult situations, and I can certainly testify to that. And finally, by no means least, we have Stefan Nerings. Stefan is a leading expert in employment, social security, and business immigration matters, and he heads our Belgian employment team and also coordinates Phil Fisher's international employment law practice. So thank you all for joining us today. Before we look at some of the detail and the challenges raised by the directive for multinational companies, I'd like to start by getting an understanding of how much awareness there is for whistleblowing protection laws in your jurisdictions. Has the directive resulted in greater awareness? Anneli, perhaps I could direct that question to you first, as Sweden was one of the first countries to introduce the directive.
Yes, thank you, Nick, and thank you for having me as a panelist today. Yes, Sweden was actually one of the first countries that implemented the directive, to be correct, on the 17th of December already 2021. So we have had it implemented for more than a year now. And we have had whistleblowing protection as in place for a number of years. However, the new whistleblowing act is much more detailed and comprehensive than the former act that we had. In comparison with the former whistleblowing act, which only comprised of 11 paragraphs, the new Swedish act, whistleblowing act, comprises of 60 paragraphs divided by 10 chapters. So it says itself that the new act is much more complex and detailed, and that has, of course, raised many questions from employers. And in addition to that, I would also say that there has been a lot of businesses that sell different whistleblowing channels, good and less good, but there have been a lot of awareness of companies blossom out of selling these channels.
Yeah, well, thank you, Annie. I've seen a number of those springing up in recent times. Barry, how about Ireland?
Hi, Nick, and it's great to be on the panel today. Delighted to be here. So there's a very high level of awareness of whistleblowing in Ireland. We've had whistleblowing laws since 2014, and the current incarnation on foot of the new directive was enacted in July 2022 and came into force on the 1st of January this year. But there is, as I say, a high level of awareness. There was a very enthusiastic adoption of the directive by the Irish government. And while maybe they were a little bit slow, they were certainly not reluctant in terms of bringing in very robust laws. And so they very much bought into the spirit of whistleblowing protection. So I would say that the concept of whistleblowing is widely known by the public. This is due to government campaigns, publicity, guides, information available online and elsewhere in the media. And speaking of the media, I think the media are very aware of this idea of whistleblowers in organizations and the possibility of penalization. And so the media are very alive to this, and they're likely to publicize high-profile incidents of whistleblowers in employment. So this all increases the awareness. And finally, Nick, of course, employment lawyers are very aware of it, and I think the employment lawyers in Ireland are very enthusiastic in trying out these new whistleblowing laws to protect their clients.
Thank you. And Laurence, is it the same in France? I know it's more recently introduced in France.
Hi, Nick, and it's a pleasure to be with you all today. So yes, in France, it's a significant change, and there was quite a lot of publicity around this recently. The concept is known to the public, although employees do not always know which level of protection they can get. As of September 1st, 2022, all employers hiring 50 or more employees shall set a whistleblowing alert. But it's not always on the top priority list of employers, as there are no big sanctions for not implementing the directive.
Thank you. And Stefan, we're only weeks away from the law taking effect in Belgium. How high is the, or what's the level of awareness in Belgium on the new whistleblowing laws?
Yes, hi everyone. Thank you for having me on the panel too. Belgium didn't have any whistleblowing legislation, in fact, until recently. So it was enacted on the 15th of December of last year, and it will become effective on the 15th of February. So that's, so to speak, tomorrow of this year, obviously. We had some channels, reporting channels, but very specific on harassment, on psychosocial risks in the certain sectors of industry, in the finance sectors and in money laundering, etc., but not an overall. So far, we had to do with legislation which was existing in respect of respecting the privacy of someone, some trade secrets, etc., which was quite difficult. So now we have that legislation, which is indeed not a copy, but based on the directive 1937. And so far, in fact, I would say companies tend to have it on their agenda more and more. So there is more and more publicity. It took about 2 years for the legislator to have this law in place. So a lot of debates, certainly also of the social partners. But so far and today, companies tend to understand the, I would say, that the benefit of such a reporting line. And why is that? Because it is primarily for every company employing 250 employees or more, as from the 15th of February, an obligation. And so it's an obligation to put up an internal reporting line. And why is it important? Because otherwise people will be able to go to externally and even eventually go into the public, to social media, and still be protected under certain conditions. So that's why I have an interest to have an internal reporting line, for sure. Other companies, 50 or more, will have to put a reporting line in place by 17th of December. And contrary to France, if you don't put a reporting line in place, it could cost you up to 4.8 million euros as a sanction to be imposed on the company because not having a reporting line. And that's certainly quite substantial, I would say.
Yeah, thank you, Stefan. So in Belgium, then, you've opted to phase the legislation in based on employer size. I think for some other jurisdictions, actually, have not opted to do that phased approach. But it's interesting because definitely seeing increased awareness and interest across all countries with the transposition of the directive. Let's turn to the directive itself now. Can each of you explain how the directive has changed your national laws? Now, I know all of you could speak at some length on the changes that the directive has introduced. So I'm going to limit you, hard as it is, to just one example of change in your jurisdiction. Maybe Laurence, can I start with you? Maybe if you could just highlight one significant change in France.
Right, Nick. So the directive has created a common legal framework for the protection of whistleblowers reporting a violation of European Union law. Before this, French law, a bit like Belgium law, was only providing for patchwork protection for whistleblowers, through specific measures depending on the industry or the size of the headcount of the company. We had specific provisions about protection of whistleblowers in the context of harassment, of course, that sort of legislation. If I can give one significant example of change, it's the change in the reporting process. Because the new law abolished the former quite formal three-step report process and now allow whistleblowers to choose between making an internal report within the company or directly with external authorities. However, and it's important to mention that the direct alert to the public remains unchanged and is only permitted in the three following cases. The first one is where there is a risk of retaliation against the whistleblower or an associated third party. The second case is where there has been no investigation carried out following the internal or external report by the employer. And the third case is where there is a serious and imminent danger to individuals or to the public interest. So that's really the, as concerned the process of the alerts, is really the most significant change.
Thank you. And Annalie, can I do the same? Can I restrict you to one example of change under the new Whistleblowing Act in Sweden?
Yeah. And since you just limit me to one example, I will give you one example that is a change for the employer. And that is a wider circle under the new current Whistleblowing Act in Sweden of people that are protected by the act. The former act that we had since 2014, that covered only whistleblowing from employees or consultants only. Today, as I said, there is a wide range of people that is covered. So in addition to the employees and the consultants, also candidates, self-employed persons, volunteers, practitioners, people within the management team, shareholders that are active in the company, and also people working at a subcontractor or a contractor for the company are covered. So there is for sure a wide range of people that is protected by the act when it comes towards the employer and its business.
Thank you. Yeah, and a much broader category of people that are protected than, say, in the UK. It's really interesting to see that development across Europe. Barry, can you give me any other examples, perhaps a change in Ireland as a result of the directive?
Absolutely, Nick. There's been a lot of change. It's a much stronger piece of legislation compared to the previous version. And what Annalie just mentioned, for example, is also the case in Ireland, much wider protection. But to give you another example, it's the reversal of the traditional burden of proof in litigation. And People on the webinar today would be familiar with the usual concept that the person who makes a claim has to prove their claim and has to prove the factual and legal basis for their claim. However, in whistleblowing situations, what the new law now does is that where a whistleblower has made their disclosure and where they allege penalization as a result of that disclosure, the burden of proof is actually on the employer to prove that any penalization or any adverse treatment wasn't as a result of the whistleblowing, but due to duly justified grounds is the phrase used in the legislation. So that's a very interesting change. And I think in practical terms, it will make it easier for whistleblowing employees to bring claims. They're more likely to bring them because they don't have to do the running, so to speak, in the litigation. And conversely, it'll make it much harder for employers to defend claims. So I think that's a really interesting and noteworthy change.
Yeah, thank you, Barry. And Stefan, again, can I limit you to one example? We've had 3 good examples, but maybe a 4th from Belgium?
Yes, Nick, so surely. We didn't have any legislation before, as I explained, but it changed quite some internal legislation. One example is that it was considered by the Belgian legislator to, well, it was considered appropriate to bring the trade secret directive together with the whistleblower directive. And as such, the legislation on the protection of trade secrets was changed. And the law provides right now that whenever there is a complaint being made or a reporting being made, which is compliant by the law, and it is composed of a trade secret, the trade secret will be deemed to have been gathered lawfully and can be made public if it serves the purposes of the Whistleblower Act. So that's quite an important change. It creates a presumption and together with a immunity, in fact, for the whistleblower, whenever he or she is making trade secrets or confidential information public.
Yeah, thank you. All right, let's turn to the discretion that the directive had. The directive sets out minimum levels of protection and standards in relation to whistleblowing, and some of those we've touched on in respect of introducing reporting channels or protections against retaliation. But many countries have gone beyond the scope of the directive in the transposition into national law. Again, I'm going to restrict it to just one example, but can you give an example whether your national law perhaps has gone beyond the scope of directive? And Laurence, maybe if I could start with you this time.
Yeah, sure, Nick. And there is a significant change here in the scope of the alert, which is not very wide, as it is extended to violations and attempts to conceal any violation of not only European Union law, but also all French laws and regulations of whichever type of laws, as well as violations of international commitments ratified or approved by France, and even unilateral acts of international organizations. So that's extremely wide. And it also covers a threat or damage to the public interest. And the new act has deleted the condition of importance of such a threat, which was required previously. So it's no more required that those threats or harm to the public interest be of a great importance.
Thank you. And I think that is common to a number of member states. We've looked to broaden the scope of reports or concerns that can be raised beyond breaches of EU law. So I think that's really important to draw out. So thanks, Laurence. Barry, is there any other areas perhaps we can touch on? I know we've spoken before about the opportunity to seek interim relief or an injunction to prevent retaliation. Perhaps you could say a little bit more on that.
Absolutely, Nick. So as you know, the directive requires that member states must provide for what they say are effective, proportionate and dissuasive penalties. So it gives a bit of scope to the member states on remedies, and Ireland has fairly enthusiastically again adopted this in terms of the remedies available to whistleblowers. You mentioned the whistleblowing injunction, which I'll talk about in a sec, but also just for attendees to know that in certain cases, whistleblowers who have been penalized can earn up to 5 years remuneration in extreme cases. So very persuasive remedies. On the whistleblowing injunction or the interim relief that you mentioned, since 2014, there has been an injunction option available for employees who say they were dismissed as a result of whistleblowing or of making a protected disclosure. And that was used not very often, but certainly we've seen a number of cases where the courts in Ireland have granted these interim injunctions, which are obviously a huge problem for an employer in those situations. But the updated legislation has gone even further, and this interim relief is now available in all sorts of situations beyond just the dismissal type situation. So for example, it's potentially available in situations like suspension, demotion, transfer of duties, a reduction of wages, or even where there's a medical or a psychiatric referral made by an employer. So that interim relief is available in all sorts of alleged penalisation situations, and we're really eager to find out how the courts are going to respond to such applications. So that's going to be very interesting stuff.
Yeah, very. Thanks, Barry. I'm just going to pause for a moment because it's pleasing to see that people are starting to ask questions in our questions function. So for those that joined a little late, we do want to make this session as interactive as possible. So if you do have any questions, please do add them to the questions function. And maybe just at this point, pose one question that's commonly asked, and that's is anonymous reporting allowed under your national legislation? Barry, I know you've just spoken, but maybe if you could just pick that one up.
Yeah, I'm happy to, Nick. Yeah, and it's a good question. So it's important to note that there's actually no obligation on an employer in Ireland to accept anonymous reports. It's optional for the employer to decide if it wants to investigate an anonymous disclosure. But also just to note that if the employer does decide to investigate an anonymous disclosure and where that disclosure or the worker's identity is subsequently revealed afterwards, that the same protections under the legislation will actually apply to that person. But the headline point is that there's no strict obligation to investigate if it's anonymous.
Thank you. And Anneli, what's the position in Sweden on anonymous reporting?
Yeah, it's more or less the same as Barry explained. Anonymous reporting in Sweden is permitted, and the employer in Sweden needs to permit anonymous reporting. So that might be a change from how it is in Ireland. And for facilitating anonymous reporting, what I've seen is that employers implement coded whistleblowing channels. Mm-hmm. However, as far as I know from my clients, anonymous reporting is not that common. They exist, but it's not that common. And what I believe is the reason for it's not being that common is because the whistleblowing channel or the reporting channel in itself often is very outdistanced from the employer. So there's not always necessary to implement also a coded whistleblowing channel. However, an issue that might raise up regarding this anonymous reporting is that if there is a person within the organization or outside the organization that wants to harm the company, they can use this anonymous reporting. So there can also be issues in connection to anonymous reporting. However, as I said earlier, an employee needs to permit anonymous reporting in Sweden.
Thank you. Certainly, and just picking up on that, I've seen lots of data that suggests people feel more empowered to self-identify and disclose their identity when raising reports. So, which is encouraging because it clearly shows that in those organisations they feel safe to raise those concerns, and therefore there's appropriate frameworks or systems in place to give people that sort of psychological safety, which is great. And of course, there's been a lot of campaigns and movements where people felt more empowered now to raise concerns, whether it's workplace concerns or otherwise. So, one hopes that moving forward, we'll see less anonymous reporting and people being able to identify when they raise their their complaints. So thank you for that. I do want to now just turn to two questions that are raised commonly, and they relate to the challenges of the directive, particularly for multinational companies, and how the directive is transposed into individual member states. The first relates to group resources and the use of group resources. Many clients operate centralized reporting systems, so often managed by a group compliance function. So they'll have a central reporting system or an investigation team. Do you see any problems with this, given the requirement in the directive to have a local reporting channel and for large companies not to share group resourcing? And how have your clients addressed this in practice? Anneli, perhaps I could just pick up again with you on that point.
Yes, thank you, Nick. Yeah, the problems, I guess we will see in the future, because now it's just we're testing the system, you know. But in Sweden, we have large companies or large companies with many subsidiary companies. They have, as I've seen regarding my clients, they have one shared channel which the employees in all these subsidiary companies and the mother company can report to. So companies that have more than 50 employees, however, less than 249 employees, sorry, they often have one shared intragroup whistleblowing channel. I have, for example, one listed company, a client that has 33 subsidiary companies. They have implemented one shared intragroup reporting channel. If that will work or if there will be a problem, we don't know yet. However, they have solved it right now by having just one channel, as I said, because all of these 33 subsidiary companies, they have more than 50 employees. However, none of them have more than 249, which then permits, pursuant to the Act, one shared intragroup reporting channel. And as you may know, in Sweden, unions are strong, and many companies, they are bound by collective bargaining agreements. And under those agreements, there's also a possibility to have provisions allowing companies with subsidiary companies with more than 249 employees to have just one shared channel, you know. So in addition to what the Act says, you can always also have provisions in a collective bargaining agreement that allows, you know, multi companies to have just one shared intragroup channel. But as far as I know, I have seen those provisions in the collective bargaining agreements. I have, however, not yet seen them in practice yet.
Yeah.
So, but I'm sure there will be such.
Thank you. And Laurence, I know it's early days in France now in terms of the introduction of these requirements, but what's the position or perhaps consensus or general commentary around this in France?
Well, in France, we have a lot of discussion about how to implement the directive as concerns those threshold of 50 employees, 249 employees, and sharing resources together, etc. Because the law does not give us much detail about this. What we don't have compared to Sweden is that generally we don't negotiate with unions about this. It's more through unilateral policies that the employer implements a whistleblowing line. So it's really not a room for negotiation here with unions. So legal experts here in France consider that in the absence of specific provisions or more detailed provisions, companies with 250 employees or more may offer two reporting channels to whistleblowers to choose. One channel with the French employer and one channel at the group level to avoid excessive centralization or disempowerment of the subsidiaries, for example, of a group. So this recommendation would, this practical solution would allow for French whistleblowers to choose a more closer contact by using the French whistleblowing line, rather than communicating with a remote team overseas. You know, and you can also imagine that there are some topics that you don't want to discuss on the local whistleblowing line because you feel that it will be too close to the general management, and there might be some retaliation to fear in those circumstances. So I think it's quite good to give the two possibilities to the whistleblowers in France. And in any case, that implies also that the group level channel complies with French rules too. So, for example, internal policies in France, they must be also available in French. That's mandatory to provide for documents in French in France. And the French employer must also have the overall control of the process. And so that's about how you deal with those alerts, with the content of the alerts and what decision you make about that. But I think we can still share, independently from those threshold of 50 or 249 employees, I think we can still share the same service provider or the same software, of course. It's just that the local employer must still be in charge and in control of this alert.
Yeah, thank you. And that, well, to me seems consistent with the written opinions, or certainly correspondence we were seeing from the EU expert group maybe a year or so ago, which suggested that the directive didn't prohibit a centralized reporting channel, but you maybe have the requirement to have a local one, and then it's for the employee who can elect either to raise their concern through a local reporting channel or a centralized group reporting channel, that option would be available, that there's no prohibition on the group or intra-group reporting channel. I think it gets a little trickier, as you say, with large companies, and when it comes to the sharing of group resourcing in terms of the various stages of considering that report or alert, in terms of triaging or the investigation or doing the any recommendations or remedial action. And I think that's an area that can be tricky and needs to just be tested in each jurisdiction, how you're going to manage that at a group level. But thank you for that. The other one I think that is quite tricky, particularly for multinational companies, moving away from the actual sort of the channel and the mechanics of that, is in terms of your policies and frameworks, whether it's possible to have a global whistleblowing policy, or whether you'd recommend a local policy, or possibly something in between. And I wonder what your clients are doing on that. Barry, maybe if I could start with you in Ireland.
Absolutely, Nick. And, you know, Laurence was talking about the importance of local flavor and providing these channels to employees. And in Ireland, when it comes to policies, I guess Ireland has a lot of national employers with, you know, employees across the globe, and we tend to see global type policies quite a lot of the time. And interestingly, in the previous version of the legislation, while it was mandatory for public sector bodies to have a policy, it wasn't strictly mandatory for private sector employers to have a policy, although it is now. And therefore, a lot more employers have been looking at their global policies to see, are they compliant with the local Irish implementing legislation? And it's early days, Nick. You know, it's only in force since the 1st of January, but already we're starting to see some issues emerge here. And I think the consensus view is that a lot of existing global whistleblowing policies might not be, strictly speaking, might not be compliant with the local Irish legislation, because the local Irish legislation, it's quite specific on a lot of things, what you must say to the employee, information you must provide to them, and particularly information on the specific channels available to them, and on the follow-up that the Irish-based employer must take on receipt of a whistleblowing disclosure. So the view is that ideally, and certainly the advice we're giving is that ideally the legislation requires a standalone Irish policy, or at a minimum, Nick, I would say an appendix which should be attached to the global policy. And understandably, global employers don't want to create unnecessary policies or have too many policies. So we've seen a little bit of resistance and a little bit of pushback on the ground, but our best advice would be ideally a local policy, if not some type of an appendix. But overall, the importance of that local flavour that we've been talking about, I think that needs to be stressed.
Yeah, thank you, Barry. And Stefan, maybe if I could bring you in here now as well, because I know you've been working on a number of interesting projects for clients which cross borders and involve a number of countries, and I wonder what your thoughts and experience with the clients are.
Yes, maybe first to state that Belgian law is a law of public order. That means there are criminal sanctions to enforce it, meaning that the Belgian legislator finds it very important. It's one of the bases of society, I would say, public order. So that means that it gives quite some attention to Belgian legislation. On the reporting, for instance, it allows a joint reporting for companies under 250 employees employing, so different companies of one group employing less than 250 employees. But once you have a group of companies and they employ more than 250, it's not allowed. Now, what we have been doing, and I can absolutely understand and follow Barry, in fact, in his reasoning, in that sense that so far we have been working on kind of a common part in a policy, which is something where the directive didn't leave any margin, in fact, for national states to have a lot of changes to be made. And on the other part, where the national legislation comes in, for instance, the material scope, we have been working together with Laurence, for instance, on a policy where the material scope in France is different from the Belgian part. We have made annexes and closures to that policy, so to address specifically the Belgian and the French needs and the French legislation. But what could be common, we have put it in a common general policy, part of the policy, then to have it, I would say, the easiest way for the employees, because that's the aim, of course, of this directive and national legislation, that is to make it easy for someone to report the violations and to make it easy to them.
Yeah, thank you. All right, I'm going to turn to some of the questions that have come in. One, I think, which is just picking up on maybe a few comments that have been made. And maybe if I could address this to you, Laurence, first. Do you need to consult works councils on either the introduction of a reporting channel or just as what we've touched on the introduction of a whistleblowing policy? I don't know what your thoughts are on that in France.
Oh, sure. Well, in France, the Works Council plays a main role. So yes, as you may guess, the Works Council must be consulted before introducing a reporting channel. And when amending the internal rules, what we call the règlement intérieur, to reflect the changes brought by the new law. So employers of 50 or more employees right now in France should amend their internal rules, add the protection of the whistleblowers in it, and to do this, as part of this process, they must consult with the Works Council first. They also have to send it to the Labour Inspectorate for review, and this must be then posted in the premises, on the intranet, etc. That's the regular process for all internal policies.
Yeah, so there's a consultation obligation or practice there, but does it go far as needing consent? I've seen some confusion on exchanges I've had with clients as to whether work council consent's needed, but no, not in France.
No,
Okay.
not in France. It's just an opinion, whether favorable or not favorable, but you don't need the consent of the Works Council on this one.
Okay, thank you. And Barry, what's the position in Ireland?
Sure, Nick. So work councils are not a big concept in Ireland. We really don't have too many works councils. We do have unions, of course, and some unionized employers might decide to consult with their unions before introducing a policy. But I would say in broad terms that there's no obligation to consult or to get consent from a union or any similar body. And really, when you think of the Irish legislation, it's quite prescriptive on what must be contained in a reporting channel. And there's very little room for maneuver on an employer in deciding exactly how to set up that channel. Obviously, in the fine detail, there might be, but in broad terms, it's quite restrictive and, as I say, prescriptive on what must be done. So it's, as long as the employer stays within those lines, it will be compliant with it. But to answer your question, no, Works Council certainly not, and even unions probably unlikely in many cases, although maybe some employers might decide to do that.
Thank you. Right, the next question, I'm just going to rephrase this slightly, but it says, how do you determine which national laws apply to internationally mobile workers? Annalie, we spoke earlier, actually. I think one of the examples you gave was the broadening of the scope of those of people that could be protected. So maybe if I could direct that to you first in terms of, would an internationally mobile worker be protected under Swedish law?
Yes, he or she would. So if the worker is conducting the work in Sweden, the Swedish Whistleblowing Act will apply. And I actually had a client that had exactly that matter on the table, and the whistleblowing channel was reported to the HR in the UK. However, that person, even though he was a British citizen, he was conducting the work in Sweden, and this HR in the UK forwarded the whistleblowing to me, and it was handled from a Swedish perspective.
Yes, great, thank you. So a very practical and real example there. Stefan, what about yours? Have you got any thoughts on that in terms of the application of say Belgian law to internationally mobile workers, particularly ones that are perhaps working in various jurisdictions?
Yeah, well, as I said, the law is of public order. That means that whenever an activity is situated on the Belgian territory, the Belgian law may become applicable. Now, we have to see which scenario of international mobility we have, because if someone is assigned by a French company to a Belgian entity, for instance, as an assignment, a secondment, probably that employee will have or will make, because he is employed by the French company, will make the reporting via the French channel, I would say. I don't think that eventually he could make the reporting on the Belgian channel, but then not as an employee. And then we have to look at the personal scope of the Belgian legislation, which is larger, of course, than only employees. It can also be third parties, it can be the staff of a supplier, and we could eventually think about the French company being a supplier or a service provider and assigning someone to Belgium, where then the Belgian, the employee could make a report to the Belgian company. But then, of course, whenever a violation occurs within his day-to-day practice as a staff of a supplier or a service provider within the Belgian entity. So I think it's dependable on the scenario which will apply. And nevertheless, again, it is of public order, and so international private law will come into play. And that means that if it cannot be distinguished which legislation will be applicable, and a Belgian judge will be competent, since it is of public order, the retaliation and the protection of Belgium will probably be applied.
Great, thank you. I'm just looking at the questions as well now. And again, for everyone, if you do have any questions, please do add them to the questions function, and we can address them during this session. There's one here which perhaps I'll just pick up briefly. It says, does the UK have to implement the directive? Short answer, no, because the transposition date fell after the date we left the EU. Longer answer, possibly, because our UK-EU Trade and Cooperation Agreement required us, although people have very short memories, but required us to keep up with EU levels of employment law. I have to say, given, I'd say the current, but the recent governments and the introduction of the EU revocation law bill, I think we're moving in a different direction and putting sunset provisions on EU-derived laws. So I think the prospect of introducing laws which are seen as EU-derived are slim. That said, there are a number of private members' bills that are looking to improve, enhance our legislation in the UK, and some of those would certainly help. But yes, no. The answer to that is no. We don't have to implement the directive, but I think there are certainly some improvements that we could make into UK legislation, and certainly the directive is raising the bar in terms of the requirements on employers and the protections afforded to employees. So that's on the UK. All right, another question. This one's an interesting one. Are employees protected if they post their concerns on social media rather than using the internal reporting channels? Stefan, perhaps if I could ask you that one.
I'm muting myself. Yes, sure. There is no specific sanction being provided by the directive. The thing is that the protection against retaliation, dismissal, can be refused if the employee, for instance, or the one who is reporting, the whistleblower, cannot prove that he did or he had to go to a public statement or to a public authority, and if he cannot prove that he had to do this because otherwise the public security would be in danger, for instance. And a second reasoning, which is stated in Belgian legislation, is that whenever the employee fears direct retaliation or fears that the proof or the evidence will be destroyed if he does it internally, so he has to go publicly, well, in that case, he will be protected. But if he cannot prove, and it is up to the whistleblower to prove that he had to go externally, he had to go to social media because there was an imminent public danger, or otherwise the proof would be destroyed. Well, if he can't prove this, he may be refused the protection provided for by the directive or the Belgian legislation. Because let's not forget, the aim of the legislation is, and this is also based on case law of the European Court of Human Rights, which precedes, in fact, the drafting of this directive, is that you have, or whenever there is a conflict, it should be resolved in first instance internally, whether to your direct supervisor, your direct manager, and certainly also use the internal channel first before going externally. Because if you go externally and you don't have good reasons, you may be refused the protection.
Thank you. And Barry, do you have any thoughts on that? What any examples perhaps in Ireland?
Yeah, so it certainly seems these days, Nick, that social media is the first port of call for a lot of people when publishing information. I mean, it's all about protection of employees, and you know, the whistleblowing directive and the national laws. They're laws that protect against penalization. Ultimately, is what they do, and potentially there could be protection for an individual who posts information on social media. But it would be risky, and it certainly would not be recommended for that employee. Similar to what Stefan said, in Ireland, you know, the legislation encourages what you could call a tiered level of disclosure. So it should start with somebody's employer or the organization they work for. After that, there are prescribed bodies or regulators, you could say, where the information could be disclosed, or the government, you know, government ministers and so on. And really, public disclosure, say on social media, to pick up your question, is really the last resort. And to qualify for protection, the employee must satisfy a much higher legal test. So, for example, they must show that they've previously attempted one of those other channels I mentioned, like their employer or a regulator, and that no action was taken. Or they might say, to pick up on Stefan's point, a similar concept, that they must show that there was some like imminent danger to the public interest or some emergency type situation. So potentially there could be that protection, Nick, but it's not recommended. And as I say, it would be a kind of a precarious thing for any individual to do without at least considering the other channels first.
Yeah, thank you. Another question, which Lawrence, I think you may have answered during the session, but maybe if I could direct this to, is there any penalty for not offering a reporting channel Maybe if I could ask you to respond to that one.
Sure. There is no specific penalty for not offering a reporting channel, which seems a bit weird, but that's it. First of all, I would say that it would be a small penalty for not including whistleblowing provisions in the internal rules, this règlement intérieur I was referring to earlier. It can also be considered as a breach of the duty of care, which can potentially trigger payment of damages to an employee. There's also a larger penalty for not granting protection to the whistleblower, and also in case of retaliation. Indeed, obstructing to the transmission of an internal or external alert is punishable in France by 1 year's imprisonment and a fine of 15,000 euros. And there's also the possibility for the criminal court to add to this penalty the posting or dissemination of the criminal decision. So, of course, an impact on the publicity about this decision. The law also, the new act in France increases the civil fine regime incurred in case an individual or company acted in a abusive manner or delayed intentionally the treatment of this alert. And they may be ordered to pay a civil fine up to 60,000 euros. And this is without prejudice to the granting of damages to the victim of the dilatory or abusive procedure. And a labor court in France may oblige also the employer to pay damages. And there's a new sanction too, which has been recently added, is that the employer be sentenced to add some monies to the whistleblower's personal training account. It's called compte personnel de formation, and this is up to 8,000 euros.
Okay, thank you. And Barry, what about in Ireland? Is there any penalty regime?
There is actually, Nick, there is a specific risk of prosecution and criminal sanctions for an employer who doesn't establish a reporting channel. Now, these sanctions could, in serious cases, in the event of prosecution, be up to 250,000 euro or imprisonment of up to 2 years. So very, very meaty sanctions. Now, in reality, I would imagine any prosecutions by the Irish authorities would really be a last resort. We don't anticipate that it's going to be very common that the authorities would need to prosecute for failure to establish a channel, but it has a persuasive effect, as you can imagine. So corporate entities and boards of directors, when they hear things like that, potential prosecutions, fines, and risk of imprisonment, I think that in itself will encourage them to make sure that they have their reporting channel in place.
Yeah, thank you. All right, I'm just going to turn to another one here. Question is, who can be sued for retaliation? I think that's a really question that's probably the other side of a question we asked and answered earlier, which was the looking at who was protected, but potentially who could be liable in relation to retaliatory actions. It's an interesting one from a UK perspective. I know we're looking at the directive today, but certainly there's an increasing trend in the UK to see individuals named as respondents in whistleblowing claims for retaliation. So they can't be liable for the dismissal itself, but you're starting to see claims for whistleblowing detriment claims. And so you'll see very often, well, quite often now, executives, non-executives being named as along with the corporate, and actually several cases now where the individuals have been found joint and severally liable for the whistleblowing compensation, in some cases quite large compensation, over £1 million sterling. Only 2 non-executives were found liable for that. So it's quite an interesting development in the UK and the UK legislation. But I wonder whether there's anything similar in your jurisdictions following the transposition of the directive. Anna, are you seeing any of that? Are you seeing employee lawyers becoming creative, seeing if they can use the directive in a way to create personal liability, or are we just seeing it as a corporate or employer liability?
Yeah, I would still say it's a corporate liability, i.e. it's the employers who can be sued. However, then we have the media, and they can always name people that are, they are behind it. But as far as the act goes, and as far as the law says, it is the employer and thus the corporate who has the responsibility.
Great, thank you, Anneli. Okay, before we draw things to a quick close, I was just wondering whether there are any concluding remarks or challenges that you've seen clients have with the directive. Just any last remarks from each of your jurisdictions. Stefan, anything that you would like to leave us with in terms of the experiences your clients have?
Yes, the unmute. Well, it clearly is going to be a culture shift in Belgium, in fact, because we are not used to have those reporting lines. It's quite close to the employee-employer. You have some reporting lines, and even those are not used frequently, I would say, because we don't see a lot of harassment cases being reported internally. It's going to be a culture change, but I think that over quite some time, people will get used to report more easily via this channel, whether on an anonymous or non-anonymous basis, because you have an obligation in Belgium to have an anonymous reporting when you employ 250 or more in place. So it's certainly going to be interesting to see the impact and how it will evolve in the next few years, and whether this reporting channel will be beneficial to the company to avoid elements and violations to be out in the big public, and to be able to solve and to address them internally within the company, or whether it's going to be the channel, although the material scope is very large, whether it's going to be the channel that is going to be abused and maybe not so beneficial to companies. So that's up to see where it will be going.
Thank you, Stefan. I think that's probably a very good point that you make for all jurisdictions, even those that have had some whistleblowing protections in place before, that this is going to be a cultural change, and we are going to see different behaviours going forward as a result of the introduction of the directive in each member state. So maybe if I take that as the concluding remark for us all, but with just a few moments left, I did want to thank all of our panelists today for their insights in the discussion. I've really enjoyed the discussion and some of the points that were raised, and so thank you very much for that. As I mentioned at the start, this session was recorded, and so we will be sharing a recording of this session with attendees afterwards. That just leaves me, though, to remind you all that this is a two-part series. So there is a second part on the 22nd of February, so it's not too late to sign up now. That session will be chaired by my colleague Christina Hutchinson, and it will have panelists from Germany, Italy, Spain, and the Netherlands. So colleagues from those 4 countries will be joining us on that day. So I hope you can join us for that event. But for now, thank you and goodbye.